Are we good? It's 7 sharp. I want to admit people. I can see all of you apart from now I can't see anyone. Okay, now you've all gone upside down. Now I can see the ceiling. 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 Hello? Can anyone hear me?
Yeah, I can hear you, Vicky. Can you hear me?
I can hear you, but I can't see anyone.
Okay, it's coming shortly.
Okay.
Oh, you have to be looking at this.
Are we good?
You'll admit Cornelius.
And me. Okay. I might have where I'm giving you like
Cornelius
Cornelius.
and
Or CK.
C Kigera.
Yes, absolutely.
C
and then there
Kigera.
is Njeri.
Yes,
And then there is
Njeri
Maina.
okay.
Waiting for Njeri now. So
Okay. So are we good? Just try talk so we see whether there are any echoes.
so I think we are set on our side.
Okay. So I can let people in because we have about 33 people waiting.
That's fine.
Just speak again.
Yeah, that's
So
what is
when
bringing.
you're when you're speaking, all the other guys have to be mute. So Njeri has to be mute unless you use one machine.
Yeah. So
you cannot be moved.
So speak.
say something, Njeri.
Hey, can you hear me?
I can hear you. The next one, but I can't see Njeri.
Yeah. Her camera is being sorted out just now. And then you can hear Cornelius.
You can hear me, yeah?
I can hear you, but oh yeah, and are you looking away? You're the one not looking at the camera.
Yes.
Okay, good. So you have different videos.
Yeah, different videos, but we're in the same room.
Okay, cool. Great. So I'm admitting everyone. Here we go. So good evening. All those who have joined us today to this webinar that we're hosting on the Sectional Properties Act. Thank you so much for joining us and making the time to attend this webinars that we ran for current country club members on issues that they are interested in and matters that they want to know more about. So thank you for joining us and feel very welcome once again. As we go along, as usual, please keep your mics muted so that we can have a good overall experience for everyone, so we don't have a lot of distractions. And then also, if you can also keep your video off, that would really, really help. But if you keep your video on, make sure you're not doing anything you don't want us to see, and then make sure your mic remains muted. So let me go ahead and introduce the webinar for tonight. So we're talking about the Sectional Properties Act, and today we're joined by Bowman's. Now, I don't know if any of you know about this, but the Ministry of Lands and Physical Planning has issued a notice to operationalize the Sectional Properties Act 2020. So what this act says is that there will no longer be registration of long-term leases over apartments, townhouses, and offices. I think maybe that means there's no more than 9999 thing that we used to know about. So we want to find out today, what does this mean for real estate developers, financiers, and owners? How will existing ownership of long-term leases be affected? And what do those undertaking new developments need to know about this new act? So today we are graciously joined by a panel of experts from Bowman's, and I will start by introducing Cornelius Kigera. And he is a partner at the Bowman's Nairobi office. He is in the banking and finance department, has been in construction, and is a property specialist. He has over 9 years post-qualification experience in all these areas. He's an advocate of the High Court, and he's a certified public accountant and a certified public secretary. I think we don't call you learned people for nothing. Welcome, Cornelius. Then I will also go ahead and introduce Alex Njage, who's also a partner at Bowman's Kenya, and he heads the Kenya Real Estate and Construction Department. He also sits in the Contracts Committee of the JBCC. He's a skilled advisor with a leading practitioner and is acknowledged by multiple leading international directories. He has a degree, an LLB degree from the University of Nairobi. Welcome, Alex, to this panel. And then last but not least, we are also joined by Njeri Maina. So Njeri Maina is an associate in Bowman's Nairobi offices. She specializes in real estate development and conveyancing, construction law, and corporate and commercial law. I think like just all the laws. So she's an advocate of the High Court of Kenya and also a member of the Law Society of Kenya and a certified public secretary. So welcome very much, Njeri, to this webinar. I will not say much other than to ask you to tell us what are they talking about when they tell us that there's a new Sectional Properties Act 2020. Who wants to start?
They've unanimously decided that I need to start, which is fine. Alex Njage here. Thank you to everyone for joining this webinar. We hope it's going to be informative. The format we'll be using is just going through what we think are the key points of law that you need to know and what the practical aspects of those points is. And then towards the end of the presentation, we're going to be having a Q&A session. Hopefully, we're going to have an interactive Q&A session. If you have any questions, you can either post them on the chat, or you can wait and ask them at the end of the presentation. I will not say much more other than that. I'm sure most of you know Bowman's. We are a full service law firm in Africa, I would say, with offices in Kenya, Uganda, Tanzania, Zambia, South Africa, Mauritius, and Ethiopia. So without further ado, let me invite my partner, Cornelius Kigera, to take us through the introduction. Thank you.
Thanks, Alex.
Let me share my screen so that everybody can see the presentation. Oh, it says the host disabled participant screen sharing.
You
I
should
think
now
someone
be
at
able
the
to share. Can you
should be
try
able
again?
to know.
Yes.
Yeah, there we go. Thank you very much.
I think you're mute. If you're speaking to us, you're mute.
Can you hear us now?
Now we can hear you.
Oh, sorry about that. I was almost done, but I'll start again.
I think you have to start from the beginning.
Yeah, sorry about that. I was saying that the commencement date of this Section of Properties Act was 28th of December 2020. And obviously, I guess the question one would ask is why since then there wasn't a lot of talk about the act until now. And I guess the reason is because a lot of us had not expected that the government would rush the implementation of the act as they have. The Sectional Properties Act is actually not a new act. We had one that was there previously. Again, the reason why that hadn't elicited as much reaction as has happened now is because it was not mandatory for everyone dealing with properties that have common areas or shared amenities to register under the Section of Properties Act. So most developers just ignored the existence of the Section of Properties Act. Government has now come back, said everybody has to go under the Section of Properties, and they issued a notice the other day saying, going forward, we are not going to accept anything other than leases that comply with the provisions of the Section of Properties Act. So that's why there has been a bit of a hullabaloo about it. The Act is intended to deal with, as I have said, properties that have shared amenities, what you would call common areas. These are things like apartments, flats, maisonettes, townhouses, or offices. But it is only in cases where there is an intention to confer ownership on different people or a number of people, not just one person. So if you are dealing with offices where you are leasing them out to people, then Section of Properties Act won't be relevant. This is only in places where you're dealing with sale of this sort of properties. If you can move to the next. Now, whilst whilst we are not very comfortable with the way government has decided to deal with implementation of the Act, I think we as Bowman, and I guess most lawyers will tell you that perhaps it's a good thing that government is trying to deal with some of the problems that we were facing in the absence of the Section of Properties Act, and we've tried to set out a few of those issues that we felt were there and is what the government intends to try and resolve. I think the biggest, and I'm sure a number of you will have seen this, is in situations where a developer has borrowed money to do the development, registered a charge over the underlying title, sold units to unsuspecting buyers, And just when he's finished paying, I mean, once the people have finished paying and now title is supposed to be issued, you realize that the developer has diverted the funds, not paid off the bank loan, and the bank is now insisting on, or rather wants to enforce its security. And there is always now a big push and pull between people who've paid the developer money and the bank that had lent the developer money and has security over the property. So that's one of the issues, and you know, as we proceed with the discussion, you know, you will see how government has tried to deal with it. And another very big problem that has been there is the issue of reversionary interest and where that rests. You know, once these units have been sold, whether it is offices or apartments, there is the underlying title. So assuming the property was freehold and you are getting leaseholds of 99 years, there is the period between the 99 years and the freehold, which is forever. There is that period, which is what we call the reversionary interest. And there has always been a problem with developers not wanting to transfer that reversionary interest to the homeowners or the buyers of the office spaces or whatever. So that's one, and that's another issue that this act tries to deal with. Another very big and contentious issue was the management company, and when shares in this management company actually gets transferred to the house buyers or the office buyers. Again, you know, as we proceed with the talk, we will see how this has now been dealt with. And lastly, you know, obviously there are many reasons, but I'm just going to highlight the main ones. I think the last one, and which is more important to government, is revenue collection. So previously, because there was only one real title, and everybody else was getting some leases issued by the developer, the rates and the rent payable on that property would have to be paid by either the management company or the developer. And in most cases, getting everybody in that development to agree to pay service charge, and for that service charge to then go towards paying the rate and the rent has always been an issue. But now what this Sectional Properties Act is doing is everybody is getting their own titles directly from government. You have an amount assigned to you for rates, you have an amount assigned for you for rent. You make the payments on your own. You are not tied to your neighbor. If your neighbor doesn't pay, that's his issue. You can pay for yours. You can get your rent clearances, and you can get your rates clearances. So that makes revenue collection, I think, for government easier. I don't know, Alex, if you want to take the next slide.
Okay, thank you, Cornelius. So I'll take you through in a pragmatic way what the new law provides in terms of sectional properties. So to the extent that you have apartments, townhouses, or offices that share one common title deed, but everyone has a sublease, say a 99-year sublease, or everyone has ownership of their respective units, then you're captured by the Sectional Properties Act. And basically what the law provides is the moment you register a sectional plan, which is, we'll be talking about it shortly, but about the process of registering sectional plans. But the moment a sectional plan is prepared and has been registered at Land's office, there are two things that happen immediately. One, which you'll see on the left-hand side of my presentation, is that a new title is issued for each unit. So if, for argument's sake, you have 10 townhouses on a piece of land with one title in Kare, the moment you register the sectional plan, then each unit is supposed to get its own title deed, right? And then each title deed will include an equal share of the common areas. So for argument's sake, if you have 10 townhouses, and say I, Alex, own one of the units, I will be given a separate title deed for my unit. And that title deed will say I also own a 1/10 share of the common areas. It doesn't specify which specific portion of the common areas is mine. so it's not divided. It's what we call an undivided share in the common areas. Then what they would also do is they would close the existing title deed for that piece of land, so that it ceases to exist. And to the extent that there were, say, for example, easements that benefit that entire piece of land that had been registered on the old title deed, those entries would be moved across to each of the new units. So the first major step of the sectional title ownership is the old title deed gets closed. You get a new title for each and every unit in that development, and that title includes a share in the common areas. So that's the one main thing that happens. The second main thing that happens is there is deemed to be established something they are calling an owners corporation. The owners corporation is akin to what people use these days, which is the management companies. And then the owners corporation is a creature of the law. So it's not established under the Companies Act. There is no other act that applies in the establishment of this owners corporation. It is just a creature of statutes under the Sectional Properties Act. So it's, for example, akin to what, for example, you'd have the Central Bank of Kenya Act establishing the Central Bank of Kenya. So there is no other registration procedure you need to go through. The law itself has declared that that entity is a separate legal entity with the ability to sue and get sued in its own name, and so on and so forth. Then each member each member in that development would have one vote, and that vote is recognized under the bylaws of the owners corporation. So that's exactly how sectional titles will be created, and what signifies that a sectional title is being created is registration of a sectional plan. Once a sectional plan is registered at Lands Office, every unit gets its own title deed. Each title deed includes a share, an undivided share in the common areas. The old title deed is closed, and to the extent that the old title was benefiting from easements or any other entries that were in the old main title, those entries are moved to each of the new title deeds for each unit. Then again, the second thing that happens when sectional plan is registered is there is this owners corporation that is established. It's supposed to undertake management and administration of the common areas, and each member will have one vote. So for purposes of existing developments where we have 99-year leases that people are holding, say for apartments or for townhouses or for offices, I'm going to describe to you the process that is undertaken to get to the point where sectional title is created. Basically, as you can see on the slides, the first action is to develop the sectional plan. For you to develop the sectional plan, you need a surveyor who will be in charge of the ground survey of each and every unit. That the product created by that surveyor needs to be signed and approved by the owner. If the owner is unwilling, the owner of the main title deed is unwilling to commence the process or to sign the plans prepared by the surveyor, then the financier can do it. And if there's no financier, then the existing management company can do it. Once that plan is prepared, it then needs to go to the Survey of Kenya for what they call authentication and approval, which still happens as of today in relation to things like deed plans, but not the georeference plans that people use for sale of sectional titles. So the survey, the sectional plan prepared by the surveyor has to go to Survey of Kenya for authentication and approval. And then finally, that sectional plan would need to be approved by the county government. And what the county government will be looking at is to see that the sectional plan conforms to whatever building plans had been approved by the county government when the relevant units were being built. That's what the county government will be looking at. So once those actors have prepared the survey plan, it's been signed off by either the owner, the financier, or the management company, and it's also been authenticated by the Survey of Kenya. It then goes to the county government, and basically the county government will be looking at whether the approvals given for the buildings on the site are properly represented in the sectional plan. As I said, the Survey of Kenya would be authenticating the sectional plan. And once that is done, that's when they then take the owner or the financier or the management company would take the approved sectional plan, the one that's been approved by authenticated by the Survey of Kenya, and basically take it to the Ministry of Lands for registration. And that would be step 3. And upon registration, as we've just discussed, the new title deed would be given for each unit. The old main title deed would be closed, and the owner's corporation is established. There is a cleanup process we think that is necessary. The law doesn't specifically provide for it, but in our view, if the management company that exists had entered into some contracts, say for garbage collection, security services, maybe water and borehole ownership and supply of water, those contracts would need to be transferred from the existing management company to the entity that will be in charge of administration and management of sectional units, of the estate, which is basically the owner's corporation. If there are any movable assets and maybe some liabilities that are sitting in the management company, those will need to be transferred to the owner's corporation as well. And then the management company will really not have any other purpose that it will be meeting, and therefore it will need to be, we need to wind it up. So that's this 4-step process for establishing sectional type. I'll now hand over to my colleague Njeri, who will speak to how the law is now regulating the sale of sectional units. Njeri?
Thank you, Alex. So now the law introduces mandatory requirements to be met by developers before selling sectional units. And those requirements are listed on the slide. So you need to provide to prospective buyers the following documents: the sale agreement, obviously, the proposed bylaws for the development, the management agreement or recreational agreement in relation to management of common areas and recreational facilities, if there are any, and if you have entered into such agreements with third parties, the main title for the property or the sectional title for the unit if the sectional plan has already been registered, the charge for in the case of finance developers, and this is a charge that's either registered against the main title or the sectional title, and the sectional plan or proposed sectional plan if the sectional plan hasn't been registered. So this is a mandatory requirement, and non-compliance attracts a fine of up to 1 year, a fine of up to 20 million Kenya shillings, or imprisonment for 1 year on default by the developer. Next slide, please. So specifically for financed buyers, over and above providing a copy of the charge to prospective buyers, the finance developer will need to provide a notice to prospective buyers, and the notice needs to set out certain details in relation to the facility. So the details are, you need to disclose the principal amount secured by your charge, the monthly installments payable under the charge by the developer, the amortization period, the term of the loan, the interest rate, and any privileges the developer will get on prepayment of the loan. Next slide, please. So once an owner has bought a unit and they don't intend on occupying the unit and wish to let it out to a third party, the law has provided certain requirements that need to be met by such owners, and these are requirements or obligations to the corporation by sectional unit owners. So before you let out your unit, you need to give a written notice to the corporation of your intention to let out the unit and the details of the tenant you intend to let it out to. In the same notice, you need to provide an undertaking that you'll be liable for any damages that are caused by the tenant that the tenant doesn't repair. And in the event that the tenant vacates the unit, then you need to give notice to the corporation that the unit is no longer let out. These notices are required for every time you have a new tenant into the sectional unit. So now, where a tenant contravenes the development's bylaws, the owner's corporation has a right and is entitled to give the tenant notice to vacate the unit. So now this is a new power granted to the owner's corporation that current management companies do not have. I'll hand over to Alex to talk a bit about the corporation.
Okay, thank you, Njeri. So I'll quickly just highlight the key items that you need to know about this owners corporation. As discussed earlier, it's a creation of the Sectional Properties Act, and therefore it's not subject to the Companies Act. It is created immediately you file a section of plan for registration at the Lands Office. How you name the owners corporation has been regulated by the law, and basically the name has to read the owners, of sectional plan number, say 180. That's how the owners corporation has to be named. Basically, they are linking the sectional plan number to the name of the company. The name of the owners corporation. It needs to have bylaws, which are similar to what you used to have as articles of association. If a corporation doesn't have its own bylaws, then the ones that have been prescribed by the law would apply. So these are the standard ones provided by the law. The corporation is not permitted to undertake any trading activities at all. So that's a specific prohibition that is in the law. No trading activities are to be undertaken. Cornelius, I don't know whether you want to talk about the challenges that this law is trying to deal with. So then we can then talk about, we can then move to the Q&A session.
Yeah, I'm happy to do that. So we've set out a few of the challenges that we see with the implementation of the Act. One of them is to do with vacant land. What has previously been happening is long-term leases have been prepared, whether it is for offices, whether it's for apartments, or it is for vacant land. Now, with the introduction of the Sectional Properties Act, everything else has been dealt with: apartments, maisonettes, offices, but there is no mention of how you can lease out vacant land. So for those developers who sell you what they call footprints, where they lease to you a piece of land and you are to then build your house, there is no mention of how that should be attended to. I think from our discussions with the Ministry of Lands, they seem to be insisting that they would want people to undertake subdivisions if they are dealing with vacant land. And obviously that has its own complications, because once a subdivision has been done, then you do not really have control of the development, and you can no longer have a controlled development there because everybody has their own title and can do what they like. So that's one of the issues we are facing, and we are in touch with the ministry to see whether that, how that can be resolved. Then the notice I had spoken about before from the ministry required immediate implementation of the Act. But unfortunately, the regulations that are supposed to back the Act are not yet in. They're not in place. We just have draft regulations which are still going through public participation, and therefore it becomes very difficult for the ministry to be able to implement without the regulations. In fact, it is impossible to implement without the regulations. So there's a bit of a problem there, because the ministry is, on the one hand, is saying let's implement. On the other hand, when you talk to the officers at the ministry, they are saying we don't have regulations, so we do not know what to do. And another issue I think we think people are going to face is, under the Act, and I think Alex has discussed this, you are required to make a conversion within the next 2 years. It will be interesting to see where you have a development where most buyers have been financed by different lenders, how those lenders will come together and agree on a route to conversion. Because each lender will have their own different requirements before they can release their leases for purposes of conversion. So I think that's also going to be another problem. Then where banks have also lent or have taken security over existing leases at the moment, and the bank now wants to enforce because there has been default in payment, how will those banks enforce, given that the ministry has now said we are no longer going to be dealing with long-term leases and you have to do a conversion? So does the lender have to wait until conversion has happened before they can enforce, or what does government intend for them to do? Then for developments, most developments, the developer is usually financed by lenders in the expectation that they will service the debt from sales, from the sales that are coming through. A lot of those sales are in turn financed by other lenders, but there's now going to be a bit of a lag, because most lenders are now going to be saying let's wait until conversion is done before we can finance these mortgages, and yet the developer has already borrowed the money and pumped in the money into the development. So again, developers may get caught out just because of this quick implementation of the Act. We can also foresee an issue with mortgage applications. I'm sure most people who've applied for mortgages to buy properties in development are now going to be, these are going to be held back by the lenders as they wait to see where this is going, and that's going to impact on a lot of the market for developers, because a lot of mortgage applicants simply won't be able to get their mortgages approved until this issue has been sorted out. And the last thing, maybe to comment about here is there had been, as soon as the ministry issued their notice saying that the implementation date was 10th of May, a meeting was held. There was a hurried meeting put together with the ministry and the LSK to discuss the impact of this implementation. A deal seemed to have been struck with the LSK, where the ministry agreed that status quo would remain until all the issues that the lawyers were raising had been dealt with. And LSK then published or issued a notice saying that we've sorted this out with the ministry. Unfortunately, the ministry, which was supposed to then support that with its own notice, did not issue the notice, and therefore, the officials at the ministries have no guidance. They can't take the word from the LSK. The ministry is not really giving guidance, and therefore we are in a bit of a lacuna there. Nobody really knows what's really happening.
Next slide. I'm going to be in a meeting 7, 8 to 9.
So we've been considering some of the ways around this that developers may want to think about. One of the things we are advising developers is where you've managed to sell all your units, then perhaps the best thing to do is to transfer the reversionary interest to the management company, and then let the management company follow up on the issues of conversion, as opposed to you getting involved in it. Where a developer has not managed to sell all the units, then we are advising that perhaps you transfer, because you can be able to lease these units to yourself. Perhaps the best thing to do is for those that are unsold, transfer them to yourself, transfer the reversionary interest, and then allow the management company, to deal with it. If you are getting into new developments, then you need to take into account that the Sectional Properties Act is going to be the new way of life. And therefore, when you're speaking to your lawyers, when you're speaking to your surveyors and your planners, you must insist on going down the route of the sectional plan and issuance of titles under the sectional plan. There is no need of attempting to do the long-term leases, because that's really not going to be the way to go. I don't know, Alex, maybe we could stop there and then deal with Q&A.
Yeah, agreed. So to the host at Current Country Club, I think now would be a good time for us to take any questions. We've tried as much as we can to respond, and Njeri is really the queen of this. She's been the one responding to all your answers on the chat. But if you haven't posted a question on the chat, or your question hasn't been answered satisfactorily, just let us have the question, and then we'll respond as quickly as we can. Maybe as people prepare their questions, I've seen a common question on the chat, which is if everyone gets a share of their the common areas as an undivided portion, then how are
Who's in my room? Where's my room?
Sorry, how are common services going to be paid for? And basically, each member under the bylaws will be required to pay, for example, a certain amount of money per month or per quarter, and that money is going to be used for purposes of defraying common costs such as security and the like. To the extent that someone doesn't pay, quote unquote, their service charge to the owners corporation, whatever mechanisms you use at the moment under the management company structure to make sure people pay, or that there is significant incentive to make sure people pay their service charge, that is still available to you. And in addition to that, what the law has done is it has given the owners corporation the power to be able to put a caveat on the title deed of a unit holder who has not paid their service charge. Putting a caveat on their title deed means that if that person ever wants to transact using their title deed, either to take a loan or to transfer it to a third party, then they will not be able to do so unless and until they pay what is due as service charge over the years. So whatever mechanisms you have at the moment, those will still be able to apply. But in addition to that, the owners corporation has the power to put a caveat on your title deed for your unit until you finish paying whatever amounts of money are due. I'm not sure who will coordinate the questions.
I can coordinate the questions.
Yeah.
I think there's still one here that I know Njeri has tried to answer.
Yes.
About the ownership of the common property, what you're calling the common utilities.
Yes.
And just clarification around how is that ownership. I can see there's Mike Dutoit who's really, really not clear about how that is calculated.
Yeah,
maybe
that's
you can
fine.
start by clarifying that one.
Okay, let me just get exactly what the question was from my colleague Njeri. Njeri, perhaps just read out the question.
So where is it? It starts up here where he asks, is the division of the common area divided by the number of titles or proportional share?
So the simplest way of doing it is, so long as someone has a unit, they get one vote. And also the division of the property will be based on the number of units. That's the easiest way to do it. So if there are 10 units, it will be everyone will get 1/10 of it. It's not necessarily proportional to the size of the property or how big it is.
Okay.
So because the common areas are for everybody, and really everyone has an equal chance to utilize those common areas.
Okay. I think
But to the extent that, just to clarify, to the extent that in your existing structures, people with bigger units or people with bigger units, for example, if they pay more service charge at the moment than those with smaller units, that structure is still available. You can adopt that for purposes of the service charge only, but in terms of ownership, they'll still have an equal share.
Okay, so in terms of owning the common areas, it's an equal share, but in terms of paying up for service charge, then that can be directly proportional to the area that you occupy, that your unit occupies. That's what you're saying.
Yeah, correct. For service charge, everyone can do whatever. The owners corporation can decide who pays what amount, and that can be based on size. To the extent that they correct, as can land rent and land rates. But ownership of the common areas, that is assumed to be equal because everyone has equal rights to use and occupy the common areas. So the right is equal to everyone. But as to how much each person is required to pay for service charge and other services, that can vary.
Okay. The other questions I'm seeing here, I think you answered when you talked about this how service charge is paid just now.
Yeah.
But there is another question: does the owners corporation collect the common expenses?
Yeah, it does. So all expenses relating to the common areas are to be dealt with, managed, administered by the owners corporation, and not by individual owners. So that structure is what will have to be adopted. So someone can't pay, for example, for their own portion of the security. No, the security money goes to the owners corporation, and then the owners corporation pays it across to the security services provider. So basically, the owners corporation is taking the position and the stead of the management company in whole. So everything that's being done by the management company right now will be done by the owners corporation. The only difference is that instead of the management company owning the common areas and the reversionary interest, under the Sectional Properties Act, each owner has an undivided share of the common areas. They cannot specify which one is theirs, but they have an equal portion in the common areas. That's the only difference.
Okay. So there's a question here from Nancy. She says, what is the downside for owners and what should they look out for when converting to comply with the new act?
I wouldn't say there is specifically any downside. The only challenge we foresee is if the developer who holds the reversionary interest doesn't want to comply with the law, or they're dragging their feet. And in that instance, then the management company, even if it doesn't have the reversionary interest, has been given power under the law to commence the process. To the extent that there's a financier who's financed a unit on the development, then that financier can also commence the process. I guess the downside is that it's going to be obviously a new exercise. Nobody knows exactly how long the process will be taking. We have various arms of government involved, the county government, the Ministry of Lands at Athi House, and the Survey of Kenya. Having those three in itself means that you probably need to have some significant lead time towards getting a title deed. Having said that, the ministry is assuring people that the process will try to be as quick as possible. So I guess the downside will be probably the time it will take and how much it's going to cost.
Okay, so you'll have to pay again to get this new title.
Yeah, well, so the government says it's going to be a free service. But then you see, you'll have to prepare a sectional plan, which will have to be prepared by your surveyor. So you have to pay your surveyor. To the extent that it goes to the county government, and maybe the county government says, oh, the sectional plan that has been prepared or what is on the ground is not the same as what we had approved in our building plans. Then you'll start having to involve your maybe an architect or a structural engineer, and so on and so forth. So these are the things we are sort of anticipating because it hasn't been done yet. But having those professionals will obviously, there will be some professional fees expense in the process. When it comes to us lawyers, again, there will be some professional fee there. What we are trying to do is come up with a product, at least at Bowman's, come up with a product where it's not expensive because it's really just conveyancing work. There isn't much in terms of legal input. It's only that the documents would then need to be drawn by lawyers and so on and so forth. So we're trying to come up with a cost-efficient product which clients can take advantage of. And we've already been in touch with the Survey of Kenya. I believe the first sectional title to be created in the country, and I'll have to check this, but I believe the first one will be in relation to the affordable housing units that have been developed in Ngara. And we've been in touch with the government surveyor who's been working on that as well. So that will help us in the sense that we'll have information on how this is supposed to be done, and then try and do it in the most efficient manner.
Okay, so in the case where maybe I know Gashanja has been answered, and when he was asked if you build a block of apartments, you do not have to take it through the Sectional Properties Act. But in the case where now you're doing your will and you're leaving certain apartments to certain maybe whoever beneficiaries, this would apply.
Yeah, so if you're building a block of apartments now and you haven't done your 99-year subleases to the people who you're selling to, you will have to convert to sectional properties. So basically, to the extent that you don't have individual 99-year leases over any units, whether it's apartments or offices or townhouses, the law says you can now not get 99-year leases. You'll have to convert to the sectional titles. And for those that have existing 99-year leases over their apartments or offices or townhouses, they will need to convert to sectional titles by the end of December 2022. So as I keep reminding my colleagues, December 2022, the year 2022 has a lot in the offing politically, but also for sectional titles, because that's the year by which you need to have converted by December 2022. If I'm living, say, one of my apartments in a block of units, say to Cornelius for that matter, in my will, then what I need to say is I'm leaving apartment number X to Cornelius. I bequeath it to him, and that apartment is registered as title number X. That in itself is sufficient. You don't need to go into much more detail as to say what the common share you're holding is and so on and so forth. Just referring to the physical description of the property and the title number is sufficient. Yeah.
Okay. I was asking in the case of where I the developer owned the apartments and they were not for rent, but now I'm leaving them for my children. I would have to convert them to sectional titles.
If you're able to convert now, that would be better. If for argument's sake someone passes on before they convert, it's the administrators who will do the conversion. The administrators of the estate, they'll have to do the conversion before they then transmit apartments to the various people who are the beneficiaries.
Okay.
Yeah.
All right. Thank you, Cornelius. Unless any other questions, I can see in the chat there's just now thank you from Mike. He says he'll touch base offline. There's thank you from Gashanja. There's a question from Lillian Wamboi though. What happens when one does not change?
Basically, it's then deemed to be an offense under the law. The penalty is, the fine is, I think, 20 million shillings. And you can be imprisoned as well, I think, for 2 or 5 years. As to whether that will be enforced, we don't know. But that's what the law provides. And then also you'll be unable to transact, as Cornelius is reminding me, you'll be unable to transact with your property, because after December 2022, I think that what the approach that will be taken is you have not converted your title deed as required to sectional titles, and therefore, yeah, you will not be permitted to transact with it. Yeah.
Okay. So unless there are any other questions, sorry, I can see there's Lucy. She's asking about commercial properties, but I think you've answered this one. Can one have sectional titles in a building with rental shops if they wanted to? I think you've answered that and said.
Yeah, you can. You can.
Yeah. Okay. So any last words before we close the webinar?
No, nothing further from us. I think it's been a pleasure presenting to you, to the members of the club. And if anyone wants to engage with us further, they can. I think, Vicky, at some point, if you feel there's any other topics you'd like Bowman to present on, just let us know and we'll be available. So thank you very much for everyone who participated today.
Thank you very, very much for coming on board. And I think the members have had, if there's any topic legal, otherwise that you feel you want tackled, Bowman is ready to come back on board. So let me thank you on behalf of the Current Country Club. I think this session has been very, very informative. And I also thank you for sharing your contacts on the chat. I saw you sharing your contacts on the chat so that anyone who wants to get in touch with you can get in touch with you. I can see someone saying here the next topic should actually be setting up trusts and wills. So maybe that's something you can look into and see.
Yeah, absolutely.
Yes, your team can give us, and we can have that.
That's fine. That's fine. We will send the presentation to you, Vicky, and then you can circulate it to the members.
That will be great. Thank you so much. So thank you everyone for attending, and I wish everyone a lovely evening. Have a good night.
Thank you. Good night.
Bye.